Testing 123, testing 123. This is a test of the Seventh Circuit Court of Appeals. Testing 123.
Good morning, ladies and gentlemen. Our first case for argument this morning is in the matter of Cook Medical. Ms. Reichmeyer.
Good morning, Your Honors. May it please the Court. My name is Jennifer Rethemeyer. I represent the two plaintiffs' appellants in this matter, Teresa Sykes and Shirley Parton, each of whom have an implantable IVC filter in their body. Medical imaging, specifically CT scans, shows that the prongs of their IVC filters have punctured outside the walls of the vena cava and into the surrounding tissue. For Ms. Sykes, the perforation is by nearly 1 centimeter, with 4 prongs outside of the wall. For Ms. Parton, the perforation is by almost 0.5 centimeter, with 1 prong outside of the wall. Each of these women has filed a product liability claim against the manufacturer of their filters, who I'll call the Cook defendants, appellees here today. These actions were filed into the multi-district litigation currently pending before the Southern District of Indiana. Ms. Sykes and Ms. Parton then both produced a court-ordered plaintiff profile sheet and a categorization form that the district court uses for bellwether screening purposes. The Cook defendants then filed the motion at issue here, which was originally a motion for judgment on the pleadings, arguing that the category selected...
What are their damages?
So the damages are the injury that they have suffered.
What injury? They're asymptomatic.
So the injury is that the prongs have poked through, punctured the wall of the IVC. This causes internal bleeding. It causes clotting.
Did it for your two clients? Did it? Is there evidence of that in the record?
There's evidence that from our expert statement, Dr. Murky, that this is what occurs in the case of a perforation, and we've documented perforations in the case of both of these plaintiffs.
But did your expert say that's what happened to these particular plaintiffs? I know he said this is a consequence or can happen, but did he actually say that happened with these plaintiffs?
That is how I read the declaration, because he states that this is what occurs in cases of perforation, and these are 2 cases of perforation.
Before we get too far down the merits, I have a question about the amount in controversy in the case. This is an MDL, but the claims are not aggravated for purposes of amount in controversy. I think you would agree with that.
Correct.
So because we're here on federal jurisdiction, each plaintiff has to have alleged damages in good faith in excess of $75,000. How do you get there? Let's start with Ms. Parton first, who is asymptomatic, hasn't alleged any kind of future damages, hasn't alleged pain and suffering. How can we say that her claim would involve over $75,000?
So there's the injury that's been suffered within her body as the starting point. Within that, you can include projected costs of future care. Also,
but there's nothing in the record about future care or future costs. I agree in a product liability case and in a defective medical device case that can be relevant, but I didn't see anything about Ms. Parton needing future care. I didn't see any, and please correct me if I missed this in the record, I didn't see anything in the record suggesting that the device was going to have to be removed. Nobody came in and opined for her health. She's going to have this come out. She didn't allege any kind of pain and suffering or future damages. How do we get to over $75,000 with respect to her?
So first of all, this issue has not been challenged.
But we do have, you're correct, and if we need to, we'll ask for a supplemental briefing and give you the opportunity to address it. So you are right, it has not been challenged, but we independently have an obligation to make sure that we have subject matter jurisdiction.
Yeah, and so to us, the fact of having suffered an injury, within the human body does give rise to that. including the attendant emotional distress that she has also suffered.
How-
In terms
how
of
did-
measuring a damages to get to the 75,000.
What emotional distress if she was asymptomatic? That if she didn't know, I'm curious as to how the CAT scan. I mean, I don't want you to get into a private health information if you don't need to, but she had a CAT scan. Was it for the purpose of determining whether these prongs have stuck through the vein, or was it for some other health purpose, and then she discovered it? You see, like, what emotional how did she suffer emotional distress?
So that comes from knowing that the filter is now outside the walls of the vena cava, and the fact that this is a condition known to be progressive. We've cited a medical journal article showing that it's progressive. It also has the emotional distress from complicating her present decision-making when it comes to her health. It's more difficult to
Where
remove
was that ever raised below, though? And where, this goes back to the question earlier, to complicate her decision-making. I didn't see anything in there from any expert or any assertion by either of these plaintiffs that they had to have the filter taken out.
So neither client has had the filter removed. We
No,
did
I'm-
present below.
But not even that somebody has told them they should have it removed. I mean, you could have something defective and with no consequences, they're asymptomatic, that stays in and you live your life without any issue. So your argument would have more merit if you had produced something below that a doctor had told her this has to come out.
What we do have is a medical journal article finding that removal is more complicated once there is perforation, which
That I don't
impacts the
doubt
distress.
that. I don't doubt that, but you're missing the first step, that you have to get it removed. I didn't see any evidence from anybody saying that once this perforates, it has to be removed, or with respect to these two plaintiffs, that they should have it removed.
So that's not in the record. What we do have is these factors that these two women now know. They have a filter that has failed within their body, punctured outside, and is now in the surrounding tissue. And we'll respectfully posit that this does impact their mental state and cause distress, knowing that this is the
Does
state
the
of...
record show, or is there an allegation, what percentage of people who have this kind of puncture end up having this device removed?
No, that's not in the record.
Does the record show what percentage of people with this kind of puncture, currently asymptomatic, develop medical symptoms in the future?
The closest that we have there is the Dowell article from 2015 discussing the progressive nature of perforations.
That doesn't tell you the answer to my question. So I take it the answer is no. There's absolutely nothing in the record
Correct.
addressing that question. All right.
Okay, I'll turn to the law then. Both sides and the district court started from the proposition that...
So I'm sorry, before you get to the merits, I want to follow up on my amount in controversy. Is it your argument that you get to the $75,000 merely by the puncturing of the filter in the IVC?
We do think that's the case because you are also entitled to look at the attendant emotional distress, projected future medical costs, and we do.
But
we think that the perforation itself does.
Is there any evidence of potential future medical costs of either of your clients, or did they allege that they were going to have any?
What we have is the fact that a filter is more difficult to remove once it has perforated. That is a more expensive, more difficult, complex procedure once you get into that.
Okay, thank you.
So turning to the law, when you look at Texas and Kentucky, the applicable state law here, the first principles are simply that injury is required. The district court and both sides then turn to the restatement for guidance. The restatement is clear that any level of physical impairment is sufficient for an injury. No minimum amount of physical injury is required. And the comments provide the example of a scratch to the bumper of a car, which is sufficient for injury. This means that the standard applied by the district court requiring a practical impact is inconsistent with the third restatement of torts. A scratch to the bumper of a car does not impact the practical ability of a car to function. It still drives from point A to point B. The Cook defendants have been more focused on the second restatement of torts, arguing that there's a difference between the two. But the third restatement addresses this. It says that, expressly says that the second restatement doesn't require that there's any minimum amount of physical harm, and gives the example of an exercise class that makes a student's muscle firmer and skin tanned, noting that that is not detrimental injury. That is not what happened here. Internal bleeding is thought to prevent death is detrimental. Scarring of the largest vein in the body is
I must
detrimental.
say I don't understand the assertion that all internal bleeding is detrimental. Everybody has nosebleeds. We don't view that as a source of damages.
Well, I think
Almost
it's,
everybody has bleeding in the lungs. Almost all of the time.
well, in this case, it's not a natural function of the human body to have a metal prong poke into a vein and
We
cause
know
bleeding.
that. But you asserted that the injury is that all internal bleeding is detrimental. And I don't see any reason to believe that's true. Now, maybe there's some reasoning behind your assertion, but the assertion itself needs support.
The FDA has evaluated that and declared that perforation is an adverse event, the risk of which counsels in favor of early removal of
Look,
these.
I wish you'd address my question. Has the FDA declared that all internal bleeding is detrimental?
No,
No, but that's what you said. That's why I said, what's the support for that proposition?
so I apologize if that was taken as a broader statement. What I meant to say is that bleeding caused by a metal prong, a foreign body, through a vein is detrimental to a
Why?
person. Because what it does is then expose the collagen, requiring fibroblast activation, clotting, and you end up with a scar on the IVC. And Dr. Murky, our expert, has a statement that that impairs the function of the IVC.
I'm not getting it. Maybe I'm just thinking of too big a universe. If you have a blood test, somebody will stick a needle into a vein. There will be internal bleeding. When the needle is removed, you can actually see that blood will pool inside the skin. Nobody classifies that as an injury leading to damages. I'm just puzzled by this assertion that any internal bleeding is a problem that will be redressed by the legal system in damages. I don't get it. You need more support for that kind of proposition.
Well, what the third restatement says about this is that any amount of harm is legally sufficient, which is the question here, is the legal sufficiency of the proof that we've offered. And it further explains that that the concern about low value cases is addressed by the fact that counsel don't bring them. There's no incentive to go and do that where the damages are too minimal. I'm trying narrowly here to address the legal question, because the district court dismissed on the ground that we couldn't establish an injury as a matter of law on these facts. And under the legal standard for injury, we think that that's incorrect, reversible error. I'll turn to toxic tort cases briefly, as both the district court and the Cook defendants rely on them. In particular, the district court pulled language out of a case called Sondag versus Pneumo Abex Corporation. It's from Illinois, applying Illinois law, addressing asbestos. And it discussed that there the allegation was that there was impact on some small number of air sacs within the lung. The court discussed that people have hundreds of millions of air sacs within the lungs, and for that reason, an additional practical detriment would be required. But that's not the case here, where we have the injury to the IVC itself. I respectfully suggest that Ms. Sykes and Ms. Parton have set forth uncontroverted medical facts from which a jury could find an actionable injury in satisfaction of the standard for summary judgment. I ask the court to overturn the district court's opinion and remand for further proceedings. Thank you.
Thank you. Mr. Paul.
Good morning, and may it please the court. Plaintiffs' lives are totally unaffected in any practical way.
Mr. Paul, we need to begin with Judge St. Eve's question.
Yes, sir. To be candid, we have had the same question, but we have chosen up to this point to accept their allegations.
You know you have an ethical obligation to address jurisdictional issues of which you're aware, not to ignore them because it's convenient.
No, and we're not ignoring them because they are inconvenient. We believe that they have alleged in good faith that these medical devices have caused them damages that exceed the amount in controversy.
How do you get the good faith here? How do you get to over $75,000? I look at I know these were direct filings. I look at their short form complaint that just incorporates allegations from the master complaint. The master complaint has a very general exceeds $75,000 allegation and has, in other places, injuries listed that don't apply to them.
Right.
So, and I know it's not all that difficult to get to over $75,000, and we do rely on good faith, but I have concerns with this massive MDL and all of these smaller cases that are asymptomatic coming in and riding the coattails of the MDL that don't meet the federal subject matter jurisdiction and don't meet diversity because they're not in excess of $75,000. So I know that hasn't been the focus.
Correct.
But can you give me some comfort on how they get to over $75,000 in good faith?
Well, the concern is fair, and our belief that they have pled in good faith the amount in controversy is based simply on our experience in medical device cases, that typically where you have a device that is in the body that has some way affected the body, even if that is not a cognizable injury, that leads to a good faith claim, a colorable claim that the amount in controversy is at least $75,000.
Does the complaint in either of these two cases explain how it gets over $75,000? The briefs certainly don't. The briefs just say the amount of controversy exceeds $75,000, period. Not the smallest effort to explain how or why.
There are no individual allegations as to either of these two cases. There is a master complaint and then a short form complaint that lays out the basis of their claim, which is the perforation.
Right.
And
the short form complaint doesn't address the $75,000 other than to incorporate the one sentence paragraph from the master complaint that says the amount in controversy exceeds $75,000.
Right.
But a lot of in fact, all of the injuries in the master complaint are not ones that have been alleged here. That's my concern.
Correct, and your concern is fair. And again, our basis for believing that they have pled the amount in controversy in good faith is based on our experience in medical device cases where you have a device implanted in the body. It is the perforation, although is not a cognizable injury, is considered an adverse event. And so we believed, based on that claim alone, that they meet the amount in controversy. That's different, of course, from the amount.
Do you feel the same way for symptomatic versus asymptomatic people? Because I have the same concerns here regarding amount in controversy, but the master complaint says that there are all these cognizable injuries such as loss of consortium, this and that. But a lot of that relates to symptomatic patients. So asymptomatic folks that had no idea that they had this condition, no problems whatsoever. I don't know how you can extrapolate those particular damages to asymptomatic individuals. And then we've got this short form complaint where you've got asymptomatic individuals just filling out, checking boxes, and adopting the damages claims in the master complaint, which clearly don't apply to them
Right.
in every instance. So what about all these other plaintiffs that have just presented the short form complaint with no additional information regarding the damages to
Yeah.
satisfy the amount in controversy?
Well, again, I can't elaborate beyond what I've already said, that our belief that they've pled a good faith allegation of $75,000 or more is based on our experience and based on the fact that they have a medical device in their body that has perforated, which is an adverse event. The good faith basis is a low bar, and that's why we've chosen to accept it. I confess that we have had the same question, but again, we have, based on our experience, chosen to accept their allegation as a good faith allegation. Now, that all said, we believe that their claims are not worth anything because they have not pled a cognizable injury. They have no adverse symptoms, they have no physical impairment, and they've had their filters for about 10 years now. Had they not
So,
got...
I'm sorry, Mr. Paul, just one more question, please, before we get to the merits. One more question on the jurisdictional amount. So our case law says that if a record is developed on the amount in controversy, that if we are legally certain that the recovery would be less than the jurisdictional amount, based on what was included in the complaint, that there's no jurisdiction. So I'm asking you, given what's in the record, is there legal certainty that the recovery here, based on what they alleged, again, not
Yeah.
based on your argument that there's no injury, but based on what they alleged their injuries were, is there legal certainty that the recovery will be less than $75,000?
No. But my understanding, and I could be wrong, please correct me if I am, my understanding is the legal certainty test comes into play when a plaintiff is put to their proof to determine
When
whether...
there's some record development,
Yes,
which I know the amount in controversy wasn't developed, but the injury
Yes.
certainly was developed. So we know we may not have a dollar amount put on in injury, but we know what she's able to claim as asymptomatic.
correct. That's a fair point. If you take the existing record and look at the issue of subject matter jurisdiction through the lens of the current evidence, then I would completely agree with you. You cannot say to a legal certainty that these claims are worth $75,000.
Again, we have to go back to what was alleged. So if there's no injury on the merits, that doesn't count.
Correct.
We have to go back to how
I
they
understand,
were
but
alleged.
what I'm saying is, if we hypothetically had put them to their proof, and this was the evidence that they came forward to attempt to satisfy the amount in controversy, then I think you could fairly say, no, this does not meet the legal certainty test. So,
It seems that this is a challenge, again, for some of these big MDL cases.
well, look, to be quite candid about this, plaintiffs have basically admitted, and I think this is from a November 2021 status conference, that the only reason these sorts of cases are filed is because of the existence of an MDL. The undoubted hope is, they wouldn't file these cases if they had to be standalone cases. The hope is that they will be wrapped up into some sort of global settlement where their individual cases will never be scrutinized on merits. And that is, courts have recognized that is a real problem with MDLs, and it is certainly a problem here.
Although there are two issues there. The MDL is meant to aggregate claims to make them worthwhile to bring, that are meritorious claims. So I think there's a distinction between being able to handle a lot of smaller dollar value claims in an aggregated way versus these claims that may not be meritorious and are tagging along.
Right, and well, class actions are typically, formed for the purpose of dealing with smaller dollar claims. But, we're dealing with an MDL, they're not
It's
generally...
not a class action here.
That's exactly right. But because there is this device for aggregating these claims, these low value or no value cases get incorporated into the MDL. And again, the hope is they will get some sort of settlement out of them without their cases ever being scrutinized. We chose to challenge these two cases on the merits, and we believe because they are asymptomatic and have no physical impairment, they have no cognizable injury. Had they not gotten their CT scans, they wouldn't even know that their filters had perforated their IVCs.
Is there anything in the record about why they got these CT scans? Was it for the purpose of the lawsuit, or was there a medical
There's
reason?
nothing in the record to that effect. And to your earlier question, to my friend on the other side about what sort of evidence is there as to treatment, there is no evidence that these plaintiffs need these filters removed. There is no evidence that they need any treatment that is different than any other filter patient would need. So there is nothing along those lines. In fact, according to their own medical journal evidence, quote, the reported incidence of symptomatic IVC perforation is low compared with the rate of observed cable wall perforation identified by CT. That's at Appendix 168. Asymptomatic perforation is the norm. It's not unusual. For there to be a cognizable injury, you have to have more than a mere change or alteration in the body, and that's because, as these cases demonstrate, physical changes may be of absolute no consequence to a person. So for there to be cognizable physical harm, there has to be a change for the worse, and it has to be for the worse in a practical sense, not just a medical, technical sense. A plaintiff has to show that there is an internal change that has a detrimental effect on their lived experience, that it is a physical impairment, such as by causing adverse symptoms like pain or some other practical detrimental effect like difficulty breathing. Here, the change is utterly of no practical consequence to the plaintiffs. And one way to see this and to address...
What about just having this foreign body in their bodies, or something that has malfunctioned in their bodies, and the emotional trouble with that?
In order to make out a claim for mental anguish, you have to have an underlying cognizable physical injury. And that's what's lacking here. That's borne out by the Capitol Holding case and the Temple Inland case. And to go to Judge Kirsch's question about what are your damages? Well, one way to see that they are not harmed in any practical way is to imagine these cases in front of a jury. How would plaintiffs go about explaining their damages? They have no adverse symptoms. They have no physical impairment. So the only basis upon which to request damages would be the threat or fear that they might suffer adverse symptoms or impairment in the future. And that alone is not a cognizable injury.
So is it your position that the statute of limitations hasn't begun to run yet for these plaintiffs?
Correct. They will not begin to run until they suffer a cognizable injury.
Because they shouldn't be boxed in. You don't have an injury, so it's premature to bring it, but you knew from that CT scan.
We can't have it both ways.
Exactly.
We can't have it both ways, which is one of the problems with their argument. If their argument is accepted, the statute of limitations will begin to run as soon as they discover they have a perforation, which means one of two things. For plaintiffs who know about a perforation but haven't sued yet, their claims could be barred. And it will not matter if they suffer serious harm later because of the rule against claim splitting. For those who know about a perforation but are still within the statute of limitations, they would have to sue whether they're symptomatic or not, and thereby risk going uncompensated or undercompensated if they don't experience serious harm during the course of the lawsuit. That does not seem like a desirable outcome if I were on the other side.
Mr. Paul, these filters, when these filters stick through the veins, do they have to be removed in some cases like think about like a pacemaker that, it's every once in a while you have to change the battery, right? I mean, these filters, when they put in, are they there forever?
They are designed to be either permanent or removable. And there is no evidence in the record that simply because they perforate, they have to be removed. And in fact, as I said earlier, there's no evidence that these specific plaintiffs...
Right. I mean, I just think about, a doctor goes into a vein with a guide wire or something like that to perform a routine surgery. Often the guide wire will get stuck through the vein and the doctor just pulls it back a little bit and the vein kind of heals itself.
Right.
Is that an injury? No. I mean, I don't think there's any argument that that's an injury. Now, the guide wire eventually comes out after the procedure. But I guess from the standpoint of the filters never have to come out because they had perforated the vein. That was my question.
Yeah, and in fact, I would be surprised if they would have to get them out at this point, given that they have already been in their bodies for 10 years now. But again, there's no evidence that they do in fact need them out. And related to your question,
I'd like to ask you the same question I asked your opponent. Are there data in this record about the percentage of filters that perforate that are in fact removed?
no, there is not. There is not.
If there's nothing there, there's nothing there.
There is record evidence about how often filters perforate, and it's not uncommon, but there is no evidence addressing your specific question.
May I ask one more question?
Of course.
Is it your position that anytime there's an asymmetric perforation, there's no injury, or that just in this case, based on these particular facts, there's no injury?
If there is no practical detrimental effect on a person's lived experience, such as by causing symptoms, there is no cognizable injury. So I think the answer to your question is no, there is no cognizable injury when the person is asymptomatic or they have not otherwise experienced some sort of detrimental effect. Thank you.
Thank you, Mr. Paul. Anything further, Ms. Rethmeyer? You have 15 seconds, but I'll extend that to one entire minute.
So I'll briefly note that counsel said that they believe we have alleged in good faith the jurisdictional requirement. Because I want to remind Your Honors that this motion at issue was originally filed as a motion for judgment on the pleadings. So there's a tremendous inconsistency to state that they believe we've alleged it in good faith, but those allegations are what was later insufficient as a cognizable injury. Beyond that, I want to note as to the November 2021 status conference, we were not there. We had no part in that statement. And in fact, we routinely turn away potential clients who have IVC filters but do not have any findings that there has been any sort of adverse event or injury. And finally, briefly as to the single action rule, I don't believe it's as simple as stating that it would really be in plaintiff's best interest to add a practical impact requirement on. These devices often fail
Thank you,
years
counsel.
after. Thank you.
The court directs both sides to file supplemental memoranda addressing the existence or non-existence of federal subject matter jurisdiction. Those memos are due in 14 days. Counsel may wish to refer to 28 U.S.C. Section 1653 in drafting those memos. The case will be taken under advisement after the memos have been received. Our next case for argument this morning is Hope against the Indiana Department of Corrections. Mr. Bartlett.
May it please the court. Indiana's ex post facto clause permits SORA's application to sex offenders registered in other jurisdictions, but exempts pre-SORA sex offenders never before required to register anywhere. The district court held that distinction lacks a rational basis because both groups pose an equal danger to the public. But that misses the ex post facto clause's point. It seeks to avoid imposing substantial, new, criminal consequences for past crimes, and exempting offenders already subject to substantially the same consequences wouldn't advance that goal. The plaintiff's response is that the ex post facto clause really seeks to, quote, enrun, end quote, right to travel protections, but this court's en banc decision forecloses that argument. It held that the ex post facto clause doesn't violate plaintiff's right to travel, does not discriminate on residency, and further rejected the argument that the federal constitution condemns laws that merely have a disparate impact on people who have traveled interstate. The court should uphold SORA as applied to the plaintiffs. I will start with addressing the district court's error before turning to the plaintiff's alternative argument. A central plank of the decision below in the plaintiff's argument on appeal is that any exemption to SORA must promote public safety to be rational. As the U.S. Supreme Court held in Fitzgerald, however, not every provision in a law must advance a single purpose. In fact, most laws predominantly serve one general purpose while having other provisions that promote other secondary and even contrary purposes.
Mr. Barta, can
That's-
you please address the district court's statement that you disclaimed any interest in fair notice by itself?
Yes, Your Honor. So I think that is just a misunderstanding of what the state argued, because at ECF 149.11, ECF 145 at 13, the state expressly argued that it struck a constitutionally sound balance between protecting the public on the one hand and the important constitutional principles of fair notice undergirding the Indiana Supreme Court's decisions in Tyson, Survey, and Ammons. And even in the footnote Your Honor mentions, the district court acknowledges the state has made that point, quote, repeatedly. And I think the district court just simply, mischaracterized the state's argument as saying the state is trying to register as many people as possible while respecting the ex post facto clause, instead of understanding that the ex post facto clause itself pursues a different goal in distinguishing between people who have registered in other states and never before required to register. And I think the clearest example of this is the Indiana Supreme Court's decision in Tyson, which provides an extensive, reasoned application of why exempting offenders already under similar obligations and subject to the same resulting stigma wouldn't advance the ex post facto clause's goal of avoiding retroactive imposition of substantial new criminal consequences for past crimes. And it walks through the 7 Mendoza-Martinez factors, explaining why the fact of registration in another jurisdiction matters to each. It would be truly extraordinary to hold that reasoned judicial analysis lacks a rational basis, because rational basis is at its most generous when defining the class of persons subject to regulatory requirement. And there has been no attempt, not by the district court, not by the plaintiffs, to show that no rational judge could decide Wallace one way, Tyson, Zerbe, and Ammons another. The plaintiffs instead, hypothesize at pages 42 and 43 of their brief that an unspecified number of people who are registered for, quote, only a few hours or might primarily be concerned about restrictions on entering schools might find SORA particularly onerous. But those concerns have nothing to do with whether the line drawn is rational for the vast majority of offenders. And rational basis review requires a court to accept a decision maker's generalizations, even when there is an imperfect fit between means and ends. In the briefing, the plaintiffs sort of pivot to this alternative argument that the Indiana's ex post facto clause really pursues an illegitimate goal of in-running right to travel protections. But that not only ignores the Indiana Supreme Court's construction of the state constitution, which explains that the ex post facto clause pursues a different goal, it also contravenes this court's prior decision. In its en banc decision, this court held that the ex post facto clause does not violate the plaintiff's right to travel. It expressly rejected the argument that the ex post facto clause treats offenders differently based on when they became residents. And it further rejected the idea that there is that laws having disparate impact on people who have traveled interstate violate the federal constitution. In rejecting that theory, the court...
Mr. Barta, I'm worried about something the parties haven't discussed, and I want to ask this question of both you and of Mr. Rose. My question is, does anything in this case matter, given the federal Sex Offender Registration and Notification Act, which appears to require all of the plaintiffs to register in Indiana?
Yes, Your Honor. I think that is a point where the record is unclear, because the federal statute requires people who have traveled interstate to register, but has a affirmative defense for situations in which registration would not be possible. And there is a question that has not been resolved by the Indiana courts as to whether the ex post facto clause would prevent state officials from registering people who voluntarily show up and say, we recognize you can't require us to register under state law, but we nonetheless wish to be placed on the registry so we don't run afoul of federal law, or whether the clause would be construed to prohibit
Has
that.
the Supreme Court of Indiana held that in its view the federal statute is unconstitutional?
It is not addressed.
It can't hold the federal statute unconstitutional under a state constitutional provision. It would have to do it under the federal constitutional provision. And that, of course, would not be consistent with Smith or with our en banc decision. So I think we have to assume that the federal statute would operate to require these plaintiffs to register. And that's why I'm asking, does anything turn on the difference between registering under the federal statute and registering under the state statute?
Yeah. So two responses, Your Honor. I agree with your point that the state constitution can't invalidate the federal statute. The only point I was trying to make is there may be an open question as to what state officials are allowed to do under the state constitution. But in terms of the practical impact, the federal registry, it may be a sort of an offense by offense basis as to what practical impact there is, because the federal registry sometimes can have different required registration for different lengths of time, and I'm not certain they would
Depending on
have
the
all the
seriousness of the underlying offense.
correct. And there may be
One reason why I ask this is it looked like all of these plaintiffs would be in the serious federal category, but maybe I'm wrong about that.
I don't know the answer to that
Okay,
question.
but look, I don't want to take too much time from your argument, but Mr. Rose should take this as a warning about my concern. Okay, please proceed.
Are the registration requirements different between the state and federal? The Indiana state registration requires certain offenders to go back multiple times, and I'm not sure if the federal requires the same thing. I don't know if you know.
I believe offhand, and with
I understand.
that the federal is just a requirement to register. I don't believe there are the same sort of granular requirements about frequency or some of the collateral restrictions on, what you might have to do if you're absent from your home for a certain period of time or homeless. So I think, but
In other words, registration under the federal statute might be less annoying.
it may be. And so I think, this really comes back to the en banc decision making clear that just because someone is registered in another state, that is not an illegitimate purpose that or does not somehow render the Indiana's ex post facto clause pursuit of avoiding imposing substantial new consequences illegitimate. One final point or observation is that I think the district court, even if one accepts the district court's understanding of disclaimer, which, as mentioned, I don't think is a fair reading of the record, that it is very hard to square the district court's characterization that the state is trying to register as many people as possible while respecting the state constitution with this court's decisions. In McCann, Speed, and Saunders, this court made clear that necessity alone can provide a rational basis for creating an exemption to a law. And even if it is legitimate to adopt an exceptions out of necessity, it is surely legitimate to adopt a constitutionally mandated exception supported by judicial reasoning while still trying to protect the public. If there are no further questions, I will reserve the remainder of my time.
Thank you, counsel. Mr. Rose.
Thank you, Your Honor, and may it please the court. Having taken Judge Easterbrook's hint, I will begin with the SORNA question. We obviously are well aware of SORNA. This is a challenge to state law, not
I
the
know
federal
that
statutes.
it's a challenge to state law. I'm just wondering what you think is in it for your clients, given the federal statute, unless you think the federal statute is also unconstitutional.
I do not, Your Honor, and there are significant differences between registration under state law and under federal law. SORNA, it's my understanding, requires you to register once, and then again, if your information changes, it doesn't require you to go back every 7, 90, 365 days. Obviously, we're talking here about not being allowed into schools, limitations on where you can live, where you can work, even the information.
Okay, so you think the state registration requirement is more onerous substantively than the federal requirement, well as more annoying procedurally?
I do think it is, Your Honor, that there are significant differences between the two. I do agree with Mr. Barta that there's a defense built in when state officials cannot actually register you pursuant to their own state constitutions that they need to abide by. And SORNA is, I don't want to say unique because I'm not aware of every statute out there, but it certainly relies on state officials for the purposes of registration in a way that federal.
Has Indiana asserted the potential federal defense that it can't be conscripted as a registrant?
They have not asserted. And
right, that would be a defense as a matter of federal law, but they have not asserted that.
That's correct,
Okay.
Judge. The bottom line in this case, and we're obviously well aware of the scrutiny that low-level scrutiny applies to any governmental classification, but in order to reverse the district court, this court needs to conclude that there is a state interest in discriminating against two groups of people for no reason other than the fact that one group of persons have at some point in their lives.
I must say I find it very hard to characterize what's going on that way. The statute unambiguously requires everybody with a certain conviction to register. And the Supreme Court of Indiana has said a subset of them, as a matter of state constitutional law, can't be required to register. How is that discriminating against anyone? The statute is comprehensive.
Judge, if the Indiana Constitution had said explicitly persons in Class A need to register, persons in Class B do not have to register, I don't think there would be any question that that constitutional provision is subject to review under the Equal Protection Clause. For all intents and purposes,
No, look, don't get me wrong. I'm not denying that this is subject to review. Anything is subject to review under the Equal Protection Clause, and our decision en banc was quite explicit. What I was questioning is why one describes the exemption of one set of persons as a form of discrimination when the statute is comprehensive. I mean, normally one would say if you single out somebody, you might call that discrimination, but the statute doesn't single out anyone. Well, it singles out people with sex convictions.
For all intents and purposes, it does, given that it can only be applied against one person, one group of persons, but not the other. What you're asking about...
Suppose Smith had come out the other way, that the vision of the dissent had been accepted, and that the application to people whose convictions predated the law had been viewed as a violation of the ex post facto clause or any other clause. Would that have made the Alaska statute unconstitutional? Because at that point, one group was in, one group was out, that was discrimination, and the only reason for the discrimination was a bunch of federal judges' interpretation of the ex post facto clause.
And those are the grandfathering clause cases, McCann, Speed, the City of New Orleans versus Duke case. But the point of those cases...
No, I wish you'd address my question. As you're depicting it, if the dissent had prevailed in Smith, the Alaska statute would have become unconstitutional because there was now discrimination against the people whose convictions were newer, right? Because they had to register. I don't think anybody would have understood that to be a consequence. But what happened here is that Indiana was persuaded by the dissent. The Supreme Court of Indiana took the position adopted by the dissent in Smith, and you say that's what made the Indiana system unconstitutional. So I don't know why it wasn't the dissent in Smith that would have made essentially all of the state registration laws
And-
unconstitutional.
And I apologize, Your Honor. I was attempting to answer the question. The reason that you can say we're going to enforce a statute, the Alaska statute in Smith, prospectively but not retroactively, isn't that equal protection doesn't apply. It's that there is a governmental interest that this court recognized in cases such as McCann and Speed in essentially fulfilling its promise. There's a reliance interest that justifies the discrimination here. We are not talking about a prospective versus retroactive distinction. We're talking about someone who committed the exact same offense on the exact same day, even in the exact same place, may have received the exact same penalty, may even have begun interacting with Indiana on the exact same date. The person who vacations in Colorado versus Texas and then comes back, the person who moves from Maine or Alaska, and only one of those persons is subject to...
And who also moved across state lines after being required to register, right?
And
Look, I don't want to argue about this, but what the Supreme Court of Indiana is trying to do is figure out how, for purposes of the dissent in Smith, which they have adopted, how to define who's being punished, right? And they come up with a definition that's different from the majority in Smith and different from the definition you would obviously prefer. But isn't it a stretch to say that the definition the Supreme Court of Indiana came up with is positively irrational, that no reasonable person could imagine any basis for it?
obviously we're not in a position to question the Indiana Supreme Court's interpretation
But you are.
of its...
And in fact, the district court said that the distinction drawn by the Supreme Court of Indiana is irrational and unconstitutional.
Applying the equal...
That's the holding in this case.
Applying equal protection analysis that was not at issue in the ex post facto cases. In any equal...
That's why I won't belabor this, but that's why I asked the question about Smith. If you took the view of the dissent in Smith, which Indiana did, you have all sorts of definitional problems, right? And then you start having the sort of problems in this case. Indiana resolved those problems in a particular way. And the district court said that the way the Supreme Court of Indiana resolved the problems entailed in adopting that view are irrational. Now, maybe they are, but we should own up to the fact that we have a federal district judge who has called the Supreme Court of Indiana irrational.
What the Indiana Supreme Court has done is it has adopted the dissent in Smith as to some persons but not as to others. Every single person we're talking about is a pre-SORA offender. Every single person committed their offense before Indiana enacted its statute. Many of them were told by the state now on remand that it does not matter even if you moved to Indiana before the other jurisdiction requirement came into effect, or even before SORA itself was enacted. Judge Easterbrook, I really can't get around the question. I do believe that what the Indiana Supreme Court did was create an equal protection violation in interpreting...
And if it did, our choice is clear. Although if we hold that the Supreme Court of Indiana acted irrationally, we force the Supreme Court to grant certiorari. There'd be no way around that.
I don't know that's true, Your Honor. But obviously, this court has to answer the question as to whether it is rational to treat this one class different from this other class. And I don't think simply saying because the Indiana Supreme Court said it's okay under the state's ex post facto clause, I don't think that satisfies equal protection scrutiny. My example still stands. If we had actually written this explicitly into the Indiana Constitution, we still have to ask, is there a legitimate state interest here? In any equal protection challenge, regardless of the level of scrutiny applied, in order to uphold a statute, there has to be a sentence that says this differential treatment that we're meting out supports the state's interest in blank. And whatever we put in the blank has to make both practical and, quite frankly, grammatical sense. I have been litigating this case for more than 6 years now, and I still don't know how the state thinks that sentence ends, other than Because the Indiana Supreme Court built us into a box. Obviously, the panel was entirely clear, since admittedly vacated panel decision, but not questioned either en banc or by the dissent in the initial opinion. That's simply not how you speak about state law. You have to ask whether the statute and its enforcement, given constitutional constraints, is something that is actually rational. I'll go back to the point that I started on, which I really do think that in order to reverse the district court, this court has to conclude that there is a reason to distinguish amongst its own citizens, Indiana's own citizens, for no reason other than the fact that at one point one of them have interacted with another state. We gave speed limits and marijuana use as an example. My understanding of Illinois law, and I might be wrong, it might just be Chicago, is that there are different, more strict rules on using cell phones while driving than there might be in other states. If another state, whether by, or if the Illinois Supreme Court or whom have you, decided that for some reason persons who travel with Minnesota, Tennessee, and Arizona plates, I'm just making up states here, are exempt from that statute, I think this court would look at the decision makers like they had three heads. But that really is the import of the state's position.
Well, you may recall, I think the only question I may have asked at the en banc oral argument was along the lines of, to adapt to your example, what if Minnesota said anybody who has a conviction out of state or in state for improper cell phone use is prohibited from driving for a year? And somebody has such a conviction in Illinois, moves to Minnesota where what that person did in Illinois would not be a crime. Would it violate the Constitution for Minnesota to carry out its penalty for acts that would not be criminal in Minnesota but are criminal in Illinois?
Obviously not, and every state has different statutes that constitute sex crimes, and they define sex offenses and sex offenders in different ways. There's nothing wrong with deferring to another state's interpretation of who is a sex offender.
And one would think the full faith and credit statute, not to mention the full faith and credit clause, requires that.
And obviously, we're certainly not challenging the plaintiff's convictions, but certainly. But this is a case where Indiana is enforcing Indiana law. It's not pretending to apply the law of any other state. Some of the plaintiffs, if they had remained in their states of conviction, their requirements would be over by now. If their requirements had actually expired before they came to Indiana, Indiana would still say, you have to register.
But none of the plaintiffs in this case are in that position.
None of them are in a position where their requirements fully expired in their other states. Two of them, I believe, are in a place where either the requirements would have expired by now or else will expire in the very near future, given the various state laws in effect. As I say, the only thing I've heard from the state is the Indiana Supreme Court painted us into a box. We readily admit that.
It's a horrible problem for the state because the Supreme Court of Indiana rejected the argument the executive branch of Indiana was making.
Obviously, the Department of Correction and the Attorney General's office would prefer Wallace have come out a different way. But
they don't want to defend. They are forced to defend the reasoning of a decision that they think is wrong.
They're forced to come.
I mean, that's life.
They're forced to come up with a rational state interest that supports what admittedly was differential results under the ex post facto clause. The fact that decision issued is alone not enough to meet that. Thank you very much.
Thank you. Anything further, Mr. Berta?
Yes, Your Honor. 3 quick points. First, to be clear, the interest Indiana is pursuing by creating this exemption to SORA through the ex post facto clause is to avoid imposing substantial new consequences for past crimes. That is what Wallace says. That is what Tyson says. Second, on the allegation that the ex post facto clause discriminates, this court in its en banc decision at page 525 said that neither SORA nor the ex post facto clause, quotes, discriminates based on residency. Adopting the view that this is discrimination because people who have a registration obligation in another state must register in Indiana would dramatically expand the right to travel and threaten a host of state laws. One example could be laws, as Judge Easterbrook mentioned, on driver's license. Others, as Nebraska pointed out in an amicus brief submitted in the prior appeal, could be laws requiring people with criminal felony convictions in other states to not be able to possess certain types of firearms, and regulatory laws as well. And I think the court could think of a number of examples of other laws that would be threatened. Statutes providing different service requirements for foreign corporations versus domestic ones, or statutes, perhaps providing, different tolling requirements. Third, on the rationality of the distinction here, a rational person who adopted the dissent's view in Smith, this really comes down to whether a rational person who adopts that view could nonetheless put limits on it. And I think Tyson makes very clear that a rational judge who, looking at, who views the dissent in Smith as persuasive in some circumstances, can nevertheless say someone registered in another state has a weaker ex post facto claim. To uphold this on rational basis, they don't have to identify a difference in kind as much as one in degree. Just as someone in City of New Orleans versus Dukes could say someone who has a pushcart license for 20 years has a stronger, expectation interest than someone who's only had it for 7, that's not a difference in degree. It's one of kind, but it is sufficient under rational basis. Thank you.
Thank you very much to both counsel. The case is taken under advisement. Our third case for argument today is United States against Richardson. Mr. Minch.
Good morning, Your Honors. May it please the Court, Theodore J. Minch on behalf of Appellant Daquan Richardson in this case. Mr. Richardson was convicted following a 2-day trial of possession of a firearm, illegal possession of a firearm under 922G. Really the sole issue that I wish to address this morning is the issue as to whether or not there was ample evidence in this case to convict Mr. Richardson of that offense.
Do you agree that that issue was not raised below?
We don't necessarily agree that that issue was not raised below. It wasn't, if the court's question is...
So it matters in terms of what the standard of review is. And I looked through everything. There was no Rule 29 followed. There was no challenge to the sufficiency of the evidence on the constructive possession anywhere, which means we look at this was a manifest miscarriage of justice committed.
That's correct, Your Honor. And so I guess
So do you agree that the standard that we look at this with is whether or not there was a manifest miscarriage of justice?
I do, because there were no Rule 29 motions filed. I do agree with that, Your Honor. So in essence, in this case, the situation as to Mr. Richardson was whether or not there was a constructive possession case that was alleged by the government. A firearm was found under the passenger seat of a vehicle that was owned by an individual who was Mr. Richardson's girlfriend. Mr. Richardson was the sole occupant of the vehicle, but again, the vehicle was owned by his girlfriend.
Mr. Minch, is there anywhere in your brief or your reply brief where you acknowledge the standard of review and attempt to show that it is satisfied?
No, Your Honor.
I read your brief as simply saying, well, I say my client is innocent. And after the United States relied on the fact that there was no Rule 29 motion, your reply brief simply ignored the problem and re-argued the same point as if there were no procedural difficulty. You see what difficulty that leaves us in. You're behind the 8 ball procedurally.
Yes, Your Honor.
And your briefs have never even attempted to show how you can meet the essential standard.
Yes, Your Honor, I do understand that, and I do appreciate that issue. Essentially, Your Honor, we're still left with the proposition of whether or not the evidence in this case arose to a level of that would support the conviction. We argue that it did not.
But the standard, again, is different. Was there a manifest miscarriage of justice when the jury found the constructive possession element?
Yes, understood, Your Honor. And we believe that given the evidence in this case, there was a manifest miscarriage of justice. There was no, we set forth in our brief the issues that were raised at trial below with regard to the evidence. There's no DNA, there's no fingerprints, there's no admissions on behalf of Mr. Richardson.
But we don't look at what there isn't. We look at what there is. And he is riding alone in a car with a loaded gun under the passenger seat that is within his reach. When he's pulled over for a minor driving violation, he doesn't give his name. The officers have to wait until they are looking through the car and inventorying it to find his name on a pay slip. They run and they find out who he is and that he's a felon. And when they ask if he has a gun permit, and his first response is, "The gun's not mine." And then he says to his girlfriend in a recorded jail call that the gun was, quote, in the same place it always is. How could that possibly be a manifest miscarriage of justice?
Well, Your Honor, we understand, again, that the test is manifest miscarriage of justice. We understand that the court needs to look at what is here and in that light. But the statements that were attributable to Mr. Richardson at trial, and I don't mean to disagree openly with your assessment of the evidence, but Mr. Richardson didn't acknowledge that he knew the gun was under the seat. It was after he was shown the gun, and then he said, "That gun is not mine."
That's not what the evidence was at trial. Again, we have to take the evidence in the light most favorable to the government. And you were free to argue at trial whatever spin on the evidence or however you wanted to put it in the light most favorable to your client. But based on viewing it in the light most favorable to the government, he was not shown the gun. The officer specifically testified that they didn't show him the gun, and instead they said to him, "Do you have a gun permit?" And he said, "That gun's not mine, it's my girlfriend's."
Well, I believe that there was also evidence in the record at trial that there was a call out with regard to a firearm being found before he was even asked.
Again, you're asking us to reweigh the evidence and to view that in the light most favorable to your client, which is not what you do on a sufficiency challenge in the first place. And when you've failed to raise it below, it's certainly not what you do on a manifest miscarriage of justice standard.
Understood, and I appreciate your position on that. Again, we believe that the evidence in this case, even the evidence that was present, the finding of guilt in this case results in a manifest miscarriage of justice as to Mr. Richardson, and we would ask the court to overturn. Thank you.
Thank you, Mr. Minch. Mr. Olson.
Good morning. May it please the court. For many of the reasons already mentioned by your honors, there is not only sufficient evidence to support the verdict in this case, but certainly not a miscarriage of justice. I also note that on reply, there is no further argument on the other points raised by appellant in
Can
this
I ask you
case.
something about that? I'm curious as to what documents the district court relied upon in determining that the defendant was an armed career criminal.
Yes, Your Honor. The district court relied on the Shepard documents, which in this case was the original verified complaint submitted at docket 2 on the district court's docket, which was superseded by indictment later on. The second document was the indictment in the state court action where his 3 prior violent felonies were alleged. Those two documents were the Shepard documents in this case and were also summarized in the PSR, to which appellant raised no objection as to the factual statements therein. Mr. Richardson also, as I mentioned in the briefing, has not cited to the court's recent decision in Wooden, contesting that there were in fact 3 prior violent felonies that subjected him to an enhanced sentence, and his adjustment for obstruction of justice certainly satisfies clear error review. We would rest on our briefing for
Mr.
those
Olson,
arguments.
I have
unless
a
the court has
question for you,
questions.
please, about the obstruction of justice. It looks like the 2 levels were given because Mr. Richardson attempted to get his girlfriend to lie about whether or not they lived together. Is there a materiality element to that? I know if a defendant takes a stand and lies and obstruction is given, it has to be that he lied about something material.
Mm-hmm.
But if you're trying to influence somebody else to testify in a certain way, is there any materiality element to that?
Yes, Your Honor. It's material to the extent that it goes to the many different facts that supported Mr. Richardson's connection to the gun. One of which was
Does it have to be material? That's as a matter of law. Our case law doesn't seem crystal clear on whether tampering with a witness, attempting to influence a witness, requires that materiality element. The obstruction of justice enhancement itself doesn't include a materiality element. We have said when a defendant perjures himself, there's materiality, but this isn't that situation. So the first question is, as a matter of law, is materiality required?
No, Your Honor. It's not in the language of the sentencing guidelines. It's not clearly stated in the comments. And as you pointed out, I'm not aware of a case that requires it to be so. The guidelines language talks about unlawfully influencing a witness directly or indirectly, or attempting to do so.
Because if it is required, how would attempting to get her to lie about where they lived be material here?
It would. It wasn't the most material fact he could have affected.
That's not the standard.
in this case, but it does go to the many different factors that go to his connection to the gun, and proving connection to the gun. In this case, the state or the government relied upon personal objects in the vehicle, relied on the fact that he lived with his girlfriend, relied on the fact that his pay stub was found in close proximity to the gun. But his fact that he was living with his girlfriend at the time of the possession is yet another fact. And so to the extent that connection to a gun as an element of constructive possession is a material fact, his living with his girlfriend at the time was material in that kind of subcategory sense of the term. If there are no further questions, the United States would rest upon.
I see none. Thank you.
Thank you, Your Honor.
Anything further, Mr. Minch?
We have nothing further. Thank you.
Well, thank you very much. The case is taken under advisement. Our next case for argument today is United States against Bailon.
Good morning, Your Honor. May it please the court. My name is Gregory Mitchell.
Mr. Mitchell.
I represent Mr. Mario Olivas Bayon. Judge, Your Honors, this case is pretty straightforward. As pointed out in the brief, and the government recognizes there's basically 2 issues here that, in terms of the Miranda warning. The first is, was he properly advised of his rights? And this is a case where, unlike you have a he said, she said sort of scenario where one person says one thing and another person says another, you have a video recording. The difference in this particular case, though, is that the defendant in this particular case does not have English as his primary language, but is Spanish speaking. And what happens in this case is really the issue is number 2. is, did he make a knowing and voluntary waiver of those rights? And that's the real question here, is what does it mean to knowingly waive the rights that you have essentially acknowledged existed?
I don't understand how that's the question here. The district court asked and answered that question. Why isn't the question for us whether the district court made a clear error?
And that's it, Judge. I believe that what the district court relied upon in terms of the issue of the burden, and as I pointed out in my brief, I think at page 21, is that the district court concluded that Mr. Olivas had been made aware of his Miranda rights, and he was now required to make a clear and unambiguous statement in order to invoke them as a custodial interrogation. And I cannot find that anywhere in the law where now the burden is on the defendant to show that he now has to request it. What we have in the other cases.
But the district court found, and this is videotaped, what the record shows is that Mr. Balin had a waiver of rights form in Spanish that he read out loud. How do you get around a written waiver in Spanish? I don't understand you to be arguing he can't read Spanish.
No, not at all. And again, looking at the video, what you have is that he's arrested at approximately 1 o'clock, and he's put into a van, and he's left there for about an hour, and he's questioned at that point.
And that was suppressed.
Exactly. But again, the test is the totality of the circumstance. So at first, you put him in a van, and he's there, and he's questioned in Spanish.
With no Miranda warnings.
And with no Miranda, and the court suppresses that. That doesn't necessarily change his psychological environment, even though that statement at that time, I'm not asking, and I filed that motion to suppress. The question becomes, Judge, is that, okay, so now we have this issue of 2 hours later, he's brought into the DEA office in Chicago.
With different agents.
With different agents, same investigation. And then he is shown a form, which is a waiver of rights form. And he is asked on the form to acknowledge the existence of each and every right. But as you look at the video, there is no discussion whatsoever about the waiver provision, that you know you have these rights, and are you now agreeing? And do you understand that by continuing to talk with us, you are abandoning those rights? Do you truly comprehend and understand?
That's on the form.
I understand.
And he signs the form.
But in the video, there is no discussion. There is no even indication, and there's no initialation where he initials every other right that he understands and abandons it by signing the waiver. And in fact, the agents who go over that form with him essentially skip that portion. They read the first top portion, and then they have him sign the bottom, where this portion that talks about waiver and abandoning the rights are simply ignored throughout the entire process. And so that's the real question, is, okay, so why would the agent simply have him selectively sign certain portions of the waiver form and then ignore the part where he understands in Spanish what waiving and abandoning the rights means? That's the real issue at this 2-hour level. And what I point out, Judge, in the case is that even though the Seventh Circuit hasn't clearly defined what knowing and voluntary of waivers means, there's other circuits who have. In fact, the Second Circuit defines it this way. Knowingly means with full awareness of the nature of the rights being abandoned and the consequences of the abandoning it. That's what that means. And there's no indication in this record that this issue of the waiver part and abandoning the rights that you just initialed was ever understood or even explained to Mr. Balin. And given his background and given the circumstances, there's no way to draw the conclusion. And when the district court says he was now required to make a clear and unambiguous statement in order to invoke them during custodial interrogation, given the context, that's just clear error. There's no indication in that regard that any court has required a person, given this scenario, what you see here on the video, that he now has to take an affirmative action to say, look, I want to have an attorney. And that's the distinction when the district court relies on Shabazz. Shabazz makes a claim that he wanted to talk to an attorney, that he was asking it. And the judge said, well, given the testimony of the agents, I don't find that testimony credible. That's not what's in this case at all. There's no credibility finding with respect to Mr. Bellion in this case. It's just simply a conclusion that the judge decided, looking at the video and looking at the reaction and essentially looking at Mr. Bellion's background, that he must have understood what it meant to waive his right to have an attorney, that he must have understood the consequences of him continuing to talk, that he must have understood all of this. And there's simply no explanation, and there's nothing in the record to indicate that. The concern here is whether or not the knowledge that the judge is simply inferring that he has can be fairly deduced from the record. And there isn't any. There is nothing to indicate that at all. In fact, what you have is that when you look at the Seventh Circuit, they talked about this, the court has talked about this in Sonnenberg in a bit, when it says that we are looking for the person to have the understanding and the appreciation of what it is they're waiving.
Was there any coercive government conduct here in getting
Well, that's
a
part of the
statement?
second argument.
The reason I ask that question is oftentimes defendants come into, especially the DEA, and they're arrested and they want to cooperate, and they sort of make this half attempt to cooperate. So their waiver and their conversations with the DEA are certainly voluntary, and there's no coercive police activity to solicit the statement from the defendant, but the statement often doesn't work out the way the defendant had hoped it would work out, particularly if the defendant is not completely truthful with the DEA. And I'm just wondering, what more should the DEA have done here if their conduct in eliciting your client's statement was not coercive in any way?
Well, again, as part two of what I pointed out in my brief, I don't think it was that they were non-coercive in any way. And again, what I consider was clearer from the district court was the district court looked as almost as this was an elements test that you look at, was there a promise made? And if there was no promise, then it was voluntary. And if was there a direct threat made? And if there was no direct threat, then it wasn't coercive. The totality of the circumstances test, from where I read the cases, is that you have to look at the entire context of what is going on here. And in this particular case, they know his status. They know from the record and what he says that I don't know anything about the drugs. And immediately the question becomes about children and deportation and legal drugs. And given the context that he's wearing his work uniform, he says, I was off work, I just came off lunch, this person picked me up, and everything that seemed to be verified, to talk about and start turning about my kids and my wife and searching my house for drugs and other things, and he's saying that you can do that, there's nothing going on. To me, that's the type of coerciveness that this court has recognized. And in fact, I think the court specifically talks about that although you can do certain things, but you have to show that it's not a threat where a person's will is overborne. And given the context of this individual, given where he stands here in his life as a working person with no criminal history whatsoever, taking care of his kids, that specifically in the context of what occurred here, his free will was overborne. And so I believe there was coercion in this case that violated the Fourth Amendment. Thank you.
Thank you, Mr. Mitchell. Ms. Partham.
May it please the court, Michelle Partham for the United States. The district court correctly held that the defendant's Miranda waiver here was both knowing and voluntary. As Judge Saini pointed out, the defendant had a written waiver form in his native language of Spanish. He read out loud each of 5 statements of rights. And while the defendant argues that he was rushed through the portion of the form that had the waiver, not only did that have a bold heading waiver of rights, but one of the 5 rights that he read aloud was, anything you say can be used against you in a court of law. That is a notification not just of a right, but of the consequences of waiving that right. He read that right aloud in Spanish. He initialed next to it, as well as the other 4 rights that he read aloud and initialed. And below the bold waiver of rights heading, he signed his full name. And the videotape of the...
I take it there's no dispute that the form is an accurate Spanish translation of the Miranda rules.
That's correct, Your Honor.
The Judicial Conference has had problems with translated forms before. I'm happy to hear that there doesn't seem to be one with this form.
That's correct. And the district court correctly found that the defendant appeared to understand the rights that he read. He didn't ask questions or show confusion, whereas elsewhere in the videotaped interview, if he was confused about something, he was willing to make that clear. And the district court also correctly found that immediately after waiving those rights, he began answering questions and cooperating. The district court also correctly held that the totality of the circumstances show that his post-waiver confession was voluntary. First, the written waiver itself is strong evidence that the subsequent statements were voluntary. Second, the record shows that the defendant confessed not in response to any challenged statement by officers, but in response to being confronted with the evidence against him. Throughout the interview, despite challenged statements, defendant consistently denied owning a gun, consistently denied involvement in or knowledge of the drug deal that was the subject of the agent's focus. It was only when an agent said they would dust the firearm for fingerprints that the defendant immediately admitted that he touched it. And watching that videotaped interview, the cause and effect there is just very apparent. He waits not a second to admit, after he was told that the firearm would be dusted for fingerprints, that yes, honestly, he did touch it. And then, after agents found a picture of the firearm in his cell phone, defendant gave additional information about the firearm. So the video shows that what prompted his confessions was not any statement about his family or his immigration status, it was the evidence. Third, defendant's conduct was cooperative throughout. He agreed to a search of his cell phone, and the district court correctly found that he consciously expressed his willingness to cooperate in exchange for leniency, asking the agents, "How can you help me?" This court has found in such cases as United States versus Brown that when a defendant seeks to strike a deal with agents, that is evidence of a voluntary, rational exercise of free will. And that's what happened here. Fourth, the defendant's demeanor. He was calm and relaxed throughout the interview. You can see in the video he's leaning back in his chair. He resisted agents' premises throughout the interview when he disagreed with them and stuck to his story. In the kind of key moments of the interview, when he's first admitting that he touched the gun, in fact, it's interesting, that is one of the most willful moments of the interview. The defendant, in that moment, an agent attempts to interrupt him. He puts his hand up. He says, "Hold on." He wants to tell his story, and he's fully within his willpower doing it in that moment. A few moments later, an agent says something he disagrees with. He says, no. So in that moment, he is showing his will. This is totally inconsistent with someone whose will has been crushed by official power. Fourth, the nature of the challenge statements. They are a very minor amount of time. In an hour-long interview, the statements that are challenged here comprise altogether less than a minute of that time. They also are truthful statements about the natural consequences of the fact that the defendant was here as an undocumented immigrant. In cases such as United States versus Miller, this court has held that there is no coercion in informing a defendant of the natural consequences of a decision not to speak with law enforcement or the natural consequences of the very serious charges for which they are being investigated. Fifth, the circumstances of the interview. This was just an hour long, middle of the day, and a largely cordial tone. And then finally, the defendant's personal characteristics. He's 35 years old, well-educated, in good condition, no drug or alcohol use. So in summary, the totality of the circumstances in this interview more than support the district court's determination that both the waiver of the Miranda rights was knowing and voluntary, and the subsequent statements were voluntary and were not coerced. If the court has no further questions, the government will conclude.
Do you agree that our opinion in Meza Rodriguez addresses the mootness issue?
I do, Your Honor.
Okay.
Thank you.
Thank you, counsel. Anything further, Mr. Mitchell? Well, Mr. Mitchell, we appreciate your willingness to accept the appointment in this case. The case is taken under advisement. Our final case of the day is Emery Investments against Utrecht America Holdings. Mr. Gant.
Good morning, Your Honors. May it please the Court. Scott Gant for the appellants, plaintiffs before the District Court. This appeal arises from a large, administratively and procedurally complex and challenging case, but the issue on appeal we submit is simple, and we respectfully submit also has a straightforward answer. Have appellants plausibly alleged a Sherman Act Section 1 claim against the defendant, Rabobank? The District Court did not cite or discuss any cases in its short order dismissing plaintiffs' claims against Rabobank, but it certainly appears to have been attempting to apply the plausibility standard announced by the Supreme Court in Twombly. The District Court, however, made numerous errors which led it to erroneously conclude that a cause of action had not been plausibly pled against Rabobank. We assume you are very familiar with our briefs, so you are aware, Your Honors, that we contend there were three basic clusters of errors in that short opinion.
Mr. Gant, can you address, please, what you think your strongest allegations are that Rabobank knew about the alleged conspiracy?
Yes, Your Honor. I'm going to directly answer your question in a moment, but because this is a complicated case, I want to make sure the Court understands one thing, which is that the complaint, which is a part of our appendix, incorporated by reference a 400-page complaint that all the direct action plaintiffs were ordered by the District Court to file jointly.
Yes, I'm aware of that.
Okay, so
I found that in the over 4,000 entries in the
yes,
docket.
my understanding is that we've broken by far the record for the most DCF filings in the Northern District of Illinois, which is a dubious distinction. I think the two clearest pieces of evidence, and Rabobank has put
Again,
these
allegations, not evidence, but
allegations, yes, and Rabobank does say we have to put forward evidence, but I think the appropriate standard is allegations. But we did have some discovery from Rabobank as a third party, and there were two emails that Rabobank has included in its supplemental appendix, which we refer to as the old production cut gospel emails. Those are at supplemental appendix 8 and 11. And those are two emails from 2011 on consecutive days from executives at Rabobank to producer, we allege, co-conspirators of Rabobank. One was Purdue and one was Pilgrim's Pride. And if I may refer to them directly, they both use the phrase old production cuts. And at the first in time was from February 24th, 2011. And that was an email to an executive at Pilgrim's Pride, CEO of Pilgrim's Pride named Bill Lovett. So this is supplemental appendix 11. It introduces, it's from an executive named Adrian Westrat at Rabobank, who was the head of their chicken consulting business in the United States. And at the end of the email, it says, I think we will see some shakeup in the industry this year unless we suddenly get some price increases in BSBM. That's boneless, skinless breast meat. That's what that acronym is. And corn comes down. Both are unfortunately unlikely. So we are left with the old, open quotes, production cuts, close quotes, gospel, followed by 2 exclamation points. And Your Honor,
is that your best evidence?
At this
I wonder how it helps you. What bugs me about this is the substantive holding of Twombly, not the procedural holding. The substantive holding is that a complaint doesn't state an antitrust claim if all it alleges is that the defendant acted in its own self-interest. In other words, it has to allege something that the defendant has acted in a way that is in its interest only if coordinated, only if other entities do the same thing. And I wonder how your complaint alleges that. Certainly what you've just referred to doesn't do that. It talks about the independent self-interest of the lender.
Well, I want to directly answer your question, Judge Easterbrook, but I want to do so in part by referring to the other email, because I think these two need to be read in tandem along with the rest of them. And of course, as you know very well, Your Honor, engaging in conspiratorial conduct can be in the self-interest of the participant. So the question is whether they engaged in the lawful pursuit of self-interest or whether they conspiratorially engaged in pursuing self-interest. There's no question here that Rabobank had a substantial financial interest in the performance of the broiler producers.
I wish you'd address my question, which is how the complaint alleges that Rabobank was behaving in a way that was not in its unilateral self-interest.
What it was doing was it knew that if, one, that all the producers needed to act together. It's very clear in the complaint and in...
Yeah, it knew that. Anybody who has looked at a downward sloping demand curve knows that. I wish you'd address my question.
I'm attempting to. So what it did is, because it knew that the industry needed to act together, is it worked with the participants, the broiler producers. There are 19 producer defendants, and went to them and said, you need to work together. If you don't work together, this isn't going to work. You're all going to fail. It gave them particular amounts that it believed it needed to cut, and in these two emails, which again, and we were only at the pleading stage, and we believe that the district court erroneously held us to a higher standard because there already had been some discovery of Rabobank as a third party. But in this second email, which is at supplemental appendix 11, sorry, at 8, the next day, this is with producer Purdue. They said, in relevant part, this is Rabobank to Purdue, you can count on us to help you in any way possible to get through this down cycle.
Yes, but did it do anything, right? It has a privilege. This is actually often known as the Colgate privilege, and I'm surprised no one discussed Colgate, to make unilateral declarations about how other people should behave.
But it didn't just do that, Your Honor. The second email is Rabobank telling Purdue that it is going to tell other producers that they need to cut. That is why that particular email, of course, you need to read it in conjunction with the email from the prior day, talking about the old production cut gospel. And of course, what does gospel refer to? It's spreading the word. It's not that word was not picked by accident. They're going to spread the word among the producers. You need to cut. And they tell Purdue, they didn't say to Purdue, we think you, Purdue, should cut. Your Honor, if that's all that happened, we had nothing else, then you might be right. But that isn't what they did. They went to Purdue and said, we're going to tell other producers that they need to cut. And why? To help you, Purdue. That is different from just pursuing your unilateral self-interest.
I don't see it. If Colgate sends the same message to every one of its customers saying, it is in our interest and yours that you engage in resale price maintenance, the Supreme Court holds that's fine, even though agreement to engage in resale price maintenance was, at the time, unlawful per se. I hope you see my problem. It looks like what you're alleging is that Rabobank sent the kind of communication allowed, indeed expressly protected by Colgate, and did not follow up in some concrete way. If it did follow up, it's in trouble, I think. But are you alleging how it followed up?
It followed up. We allege that there was an agreement, that these emails were an illustration of a broader agreement to facilitate communications among the producer participants and to convene them together and then tell them what they all needed to do to give them opportunities to reach agreements. So I respectfully just reject the suggestion that this is just factually like Colgate. And I apologize, I don't remember the procedural posture of Colgate. And as you pointed out, Rabobank didn't rely on that, so I didn't review it for the argument preparation. But of course, we're at the pleading stage. And the Supreme Court is very clear, and this court has been clear, and Your Honor, it was 13 years ago now, but you may remember the Swanson decision in which you joined Judge Wood in 2010, which said that at the pleading stage, plausibility does not imply that the district court should decide whose version to believe or which version is more likely than not. We were at the beginning of discovery. We were entitled to 10 depositions of Rabobank under the district court's discovery orders. We were negotiating with them additional document requests. We left open the 2 third-party depositions that occurred because Rabobank wouldn't sign the protective order that would allow us to show them confidentially marked documents produced by other defendants at the deposition, and they didn't produce all the documents prior to the deposition. So Rabobank contested our position, but our position was those depositions were left over. So we were early in discovery. This is a pleading standard governed by Rule 8 and Rule 12. The Supreme Court's been clear that the rules control, that the courts are not allowed to impose requirements beyond those set forth by the rules. Twombly itself said, and this court said in Swanson, that Twombly is an interpretation of Rule 8. The district court simply went too far. It does what Judge Easterbrook we know is not permitted. The Supreme Court has said, you don't make a determination about who you think is going to be right. The question is, have you plausibly set forth a claim? And we believe we have. I see my time's expired, but of course I'm happy to answer other questions at this time.
Certainly, Mr. Gant. Mr. Doyle.
Thank you very much, Your Honors. Good morning. May it please the Court. David Doyle on behalf of the Rabobank defendants. I do believe this appeal concerns a very straightforward application of the federal pleading standards that were articulated in Twombly and Iqbal, and I also do believe that Judge Easterbrook has hit on the key legal principle that is dispositive of this appeal. When you evaluate the plausibility of Section 1 allegations, if the allegations are equally consistent with innocent conduct and participation in a conspiracy, the plaintiff has failed to state a claim. The plaintiff has not nudged the allegations across that line from consistent with or possible or conceivable to plausible. That's very clear, and in fact, a member of this panel just last year in the Marion Diagnostic Center case stated that Twombly demonstrates that courts should dismiss antitrust conspiracy complaints for failure to state a claim when the allegations taken as true could just as easily reflect innocent conduct or rational self-interest. That is, respectfully, this case. All of the conduct that's attributed to...
I hope it also included the word unilateral, because the classic cartel is in the self-interest of all the cartel members.
Certainly, Judge.
That's not enough to let it off the hook.
Correct, but here, look at what they're alleged to have done. Rabobank, what did it do? It monitored the chicken industry. It talked to its clients about supply restraint. It had communications with executives from poultry companies. It maybe even went so far as to say, boy, if you don't start to do something to address the economic woes of this industry, we may not be there a year or two down the road. But that is exactly the type of dialogue and exactly the type of conduct that you would expect from a major bank with hundreds of millions of dollars in lending exposure to a number of chicken producers that were facing unprecedented economic difficulties. So in each and every case, if you look at, whether you look at this evidence individually, whether you look at it collectively, it's exactly what you would expect Rabobank to do. And I would submit that these preach the gospel emails...
Really? I mean, all that it did for Rabobank was land it in expensive litigation and require it to pay your legal fees, if not treble damages. Why didn't it just send everybody an article written by Joan Robinson explaining how cartels work?
Well, Judge, I would submit, and I've done those CLEs and I've talked to companies about their emails, and nobody thinks that what they write, and that's a very informal mode of communication, nobody thinks that a year or two or 5 years or 10 years down the line, it's going to be produced and they're going to be questioned about it. Yes. But the bottom line, Judge, is those communications and that advice, not at all dissimilar from, and we cited in our brief in a footnote, a number of different articles that journalists and professors and other people were saying, there's just too much chicken out there, right? So this was not an earth-shattering revelation. This was not, and most importantly, I think, for purposes of this appeal.
Is there any clue in this record why whoever was writing these imprudent emails at Rabobank thought that the chicken industry of all industries needed to know these things? There's been this drumbeat of antitrust litigation about the chicken industry for at least 50 years, maybe more.
I can't answer that question, and I'll confess to you that there is nothing in the record. And Mr. Westrady, who authored those emails, is no longer with us. He has passed. So there never will be an answer to that
In the
question.
history of that I trust, it almost rivals the fine paper industry. But I know you can't go back and deal with your client before the emails were written.
Well, but Your Honor, in defense of my client, we have an alleged massive, sprawling, 20-some entity conspiracy that went on for 11 years, and we have 2 emails that do not reflect industry-wide communications, that were one-on-one communications with poultry executives, although, as Mr. Gant says, there was some promise there to spread the word, but they're not at all reflective of some knowledge of a conspiracy. And another way to look at it is, as this court is well aware, conscious parallelism or follow the leader conduct is perfectly appropriate. And what is it to say about these emails that isn't what Rabobank was hoping for? In other words, you Purdue, please cut supply, because then maybe Pilgrim's Pride will do it, and then maybe Tyson will do it, and then maybe somebody else will do it, and before you know it, steps have been taken within the industry to fix the economic woes that it's experiencing. All of these communications are equally consistent with that type of hope and wishful thinking. And they're also equally consistent with Rabobank's self-interest as a lender. So for those reasons, I don't think you can look, and that's a great question you ask. Give me your best evidence. What is your allegation? What is your strongest allegation? You put that question to Mr. Gant, and he answered it. And in fact, the district court was very unimpressed by that, and was looking to see, because the theory is that Rabobank is a conduit for information, was looking to see communications amongst the chicken producers, and was looking to see information conveyed by Rabobank to the chicken producers that they could use, and actually did use, in implementing this alleged conspiracy. You don't have any of that. And I commend to the court's review, and maybe you have reviewed it already, although it's a district court case and it's fairly recent, in the In Re local TV advertising case. Judge Kendall wrote a wonderful opinion in August of last year. And the case is very similar to this one. You had a DOJ investigation. You had a horizontal conspiracy among competitors. You had a motion to dismiss filed by all those competitors, and a denial of that motion. And then sometime later, they added a new defendant, and that defendant was not a part of the industry, was not a broadcaster, but was somebody that was supplying information to broadcasters that supposedly could be used to facilitate the conspiracy. We cited this case in our brief.
I'm not sure how helpful that case is to you, though, because the court relies a lot on this opinion in this case that's being challenged for its reasoning. So if there were separate reasoning, I would understand your point, but there's heavy reliance on Judge Durkin's opinion in this case that's now on appeal. So I think your argument only gets you so far based on reliance on that opinion.
I think that's fair, but I think there's a reason for that. You don't see a lot of cases like this, right? We are not members of the alleged conspiracy that did these supposed reductions in production, right, or price fixing. We don't have any control over the means of productions. We don't have any input into the decisions that the chicken producers made. Our fortunes don't rise or fall depending on any specific reduction in price. And in that case, Your Honor, Judge Kendall did cite some other authority and looked at this theory of being a conduit for information and said, well, boy, at a minimum, you have to show how that information could be useful to the people that are supposedly implementing the conspiracy. In the case of AgriStats, you have that. You have a consultant that went to the chicken producers, gathered information, distributed it to the producers in a way that was supposedly anonymized, but according to the allegation, allowed them to gain an insight into what everybody was doing, what all the competitors were doing from a pricing and production standpoint. Right or wrong, that's the allegation. And Judge Durkin found below that if they disseminated that information, which was supposed to be a critical tool in the implementation of the conspiracy, it's plausible to suggest that they knew of the conspiracy. And with Rabobank, you have nothing even remotely resembling that. Now, in the TV advertising case, there was information that was provided about inventory and pricing and things that you could at least make a colorable argument could be used and informative to the members of the conspiracy, alleged conspiracy. You don't have that here. You simply don't. And so what my opponent is left with is criticisms of the district court that I really don't think have any merit, suggesting that he ruled the way he did because Rabobank is a bank and not a member of not a chicken producer. In fact, in his first motion to dismiss ruling, he directly contradicted that notion, suggesting that we don't know the decisional authority that Judge Durkin relied on. When you have a judge, and Judge St. Eve, we're over 6,200 entries in the docket now, as of this morning. Good heavens, right? We have a judge that's doing an unbelievable job administering the most massive piece of litigation I've ever heard of, much less been involved in. And he has written over 100 pages.
Do you know anything about the Cook Medical case? It was the first case argued this morning, a real sprawling piece.
Okay.
Yeah. You don't want to make comparisons.
All right.
You
Well,
know about that case, too.
Say a non-MDL.
In my little world, this is a biggie. But he wrote, and I know my time is up, but he's written over 100 pages of motion to dismiss rulings. He's a very experienced judge that is very familiar with the pleading standards in federal court, and I think he
I
did.
can assure you that Judge Young in Cook Medical has written a lot more than 100 pages.
So with that, unless the court has any other questions, on behalf of my client, we thank you for your time and your attention. We ask that this court affirm the decision of the district court and dismiss the allegations against Rabobank.
Thank you very much. Mr.
Thank you,
Doyle,
Judge.
anything further? You had a few seconds left, but I'll round you up to a minute.
In Twomley, ultimately, this is a motion to dismiss. We deserve the opportunity to finish discovery, including discovery since we filed our opening brief in this case, where we asked Bill Lovett, the CEO of Pilgrims, the recipient of one of those production cut gospel emails, about the email, and he invoked his Fifth Amendment right against self-incrimination. We deserve the opportunity, respectfully, to go back to the district court. The Rabobank's arguments before the court and before this court, before the district court and this court, as exemplified by their supplemental appendix, are summary judgment arguments. This is a pleading case with pleading standards. We sufficiently pled a plausible Section 1 claim, and we deserve the opportunity to go back and try and prove it. Unless there are further questions, I thank the court for its time.
Thank you very much. The case is under advisement, and the court will be in recess for today.